Hello, my name is Howard Miller. This morning I presented about a recent Second Circuit case that was a case of first impression that held that academic freedom in the context of a university is protected by the First Amendment. So the name of the case is Heim versus Daniels, and you had a professor at SUNY Albany who teaches economics. And he claims that he was not given a tenure-bearing position because the model of economics that he teaches in his classroom is known as Keynesian. And that model is not in favor of the rest of the department at SUNY's economic department. And the Second Circuit, for the first time, held that the fact that there are differing and a robust debate on what methodology should be used in a classroom setting makes it such that that speech is protected by the First Amendment, because in the unique context of a university is the marketplace of ideas, and we should allow professors to espouse ideas that may not be in accord with the rest of the university. Although the Second Circuit held that that speech was protected, the professor still lost the case. And the reason is that the Second Circuit employed a balancing test. And what the court said is, yes, you have the right to academic freedom, but a university has a right to decide what level of scholarship is going to be necessary to be granted tenure. And on this basis, the university had the right to say, we don't believe in that Keynesian model of teaching, and we want our professors to have a certain level of scholarship in another methodology. And because of that, the university prevailed in the case. Now, the Second Circuit left open the possibility that there may come a time where a professor is going to win in this kind of case. And that could be, for example, where you have somebody teaching political science and the political science teacher is fostering a debate about, let's say, the war in Ukraine and whether the US is having the proper level of support for Ukraine. I think in that context where we're just talking about pure opinion that's part of a classroom discussion as opposed to an entire methodology that is contrary to the methodology wanted to be used by a college, that in that situation, the professor is likely to prevail. Now, because of this was a case of first impression, and there's going to be a lot of cases to follow it, if a client is going to be considering some sort of adverse action, whether it be termination or declining tenure to someone who is engaged in this type of classroom instruction, you ought to discuss this with counsel first. So thank you.